Acaba de unirse el doctor Carrillo, es el Procurador General de Colombia y los acaba de saludar. Vamos a,
Así
we're
es.
going to start with the transmission. Okay, we're just going to start. Good morning, everyone. I'm Diana Narga, Director of the Institute. We have 304 people online in YouTube, and I'm going to start the live streaming and make sure that everything is in place so we can start. Greetings to everyone. Mr. Khalid, if I can please ask you to switch to the Spanish channel. In the bottom of your screen, there's a button bar and you'll see the interpretation icon. Can you please choose Spanish? Thank you. Can we start, Diana? We're just waiting for your green light to go, that we are live in YouTube. It's working, great. Good to go. Good luck. I'm sorry, someone is, who is Vanessa Espejo? She's sharing her screen and she shouldn't. Let me check on that. Go ahead. Well, very good morning to everyone. Welcome to this training, virtual training on environmental boards and jurisdictions. Thank you very much for joining us today in this training. It's been organized with the support of the General Prosecutor's Office, together with ELI and GGDI, and with the support of the Institute of Studies of the Public Ministry. We have close to 300 people who have joined us to our live streaming in YouTube. I am Angela Maya, and I'm going to be with you moderating today's session. Very briefly, I'd like to tell you what we are going to cover, the structure of our seminar. Our seminar will be taught during 4 sessions, 4 Thursdays during the mornings. Well, actually, one day will be at noon. Today's session will be looking at core century environmental core century specializing in uh, the transformation of environmental jurisdiction, how they come together. Sessions 2 and 3 will have the support of judges from other countries who will be telling us their experience in every one of their jurisdictions, how they have put these courts together, how they become structured. And then July 9th, there will be a more general session on discussion on best practices and recommendations from what we've heard from these experts to create an environmental jurisdiction. The presenters who will be with us throughout these sessions are Meredith Wright, former judge in the Environmental Court of Vermont in the U.S., former judge under Vextus from Land Environmental Court in Sweden, Jeffrey Cartwright from Hawaii in the United States, Michael Hagdamas from Valdivia, Chile, Antonio Herman Benjamin, Ministry of the Tribunal of Justice Tribunal in Brazil, and Judge Carla Hernandez, the first environmental court in Guatemala. To the agenda for today, here's what we're going to do. We'll start, we'll listen to Fernando Carrillo, General Prosecutor's Office, and then we'll listen to a presentation about the seminar by Carl Burke, he is the project leader. Thank you very much. Mr. Carrillo, thank you for joining us, and the floor is yours. Well, thank you, everyone. I'd like to bring greetings, especially for Carl Burke. The judges and former judges will be with us, especially Meredith Wright and Vermont, Anders Bexen from Sweden, and everyone who's made this possible. Miguel Lendoño, thank you for your participation and GGI's contribution to this project. I think it shows that in spite of the difficulties imposed by the pandemic, we can clearly see that these opportunities to connect with one another globally become clearer and clearer. It's a paradox, especially in the confinement we have become more global in response to the solution. There's so many issues that have impacted us. I also want to say hello to Oscar Dario Amaya. He's a magistrate from the State Council bench, Gloria Amparo Rodriguez, also from JEP, Jorge Juan Palacio, one of the points of reference in Colombia, one of the benchmarks regarding environmental law when he was a magistrate of the Constitutional Court in Colombia. And Diego Trujillo, our delegate, environmental delegate, and as well as Diana and others from the Institute of Studies. I think the world is living a big paradox. A paradox that is that what climate change did not achieve, nor environmental degradation achieved, is being achieved by this pandemic that we call coronavirus. It was to stop the world for the bad in many senses, for the good things that were being done, but also to paralyze it in the devastation and all the crimes we're committing against the environment, all the abuse we humans are committing against the environment. Here in Colombia, just to give you some figures, over 18,000 people died because of poor water quality, poor air quality, and then to think about the opportunities offered by this moment to try to change certain behaviors that we've had in the past and to take steps forward regarding the commitments we have to protect nature and the environment, then I believe that's key. I'd like to highlight the organization of these sessions because I believe that we've been highlighting for a long time the importance of justice in the decisions of budget to have big agreements, global agreements, where the validity of the rule of law in a state like Colombia, where the government plays a key role. This has been the case in Colombia since the Constitution of 1991. It's a commitment to all of us to see if we can together take actions which imply strong practices to avoid this wrong path that humanity had taken out against the environmental rights and, of course, against sustainability of human race. It's funny to see because in addition to the comparison to what's happening right now, that's been what Thorne is called the principal prince princess right. This is something that we had foreseen before. It turns out that the reduction on the impact environment started a long time ago, but we continue to delay and delay solutions. We continue to prolong our global commitment as well as the national commitment. That's why I believe today there is this opportunity to take action in response to what's been happening in the last 100 days or so in the world. And it's time to revive with a lot more power, to revive these people, all of us, to think about strengthening our institution, to strengthen the instances at the private and public levels that have contributed with their efforts to take these actions. And there's another element that is key, and it's the proliferation of conflicts in this area. The proliferation of environmental conflict demands, for example, that we make adjustments in our global and national agendas. It also demands that we deliver to judges a decision power. In the case in Colombia, I'll be touching on that. That's been a key point. Somehow, judges have taken the lead in solving environmental conflicts. In the case of Colombia, as we've seen in sentences, rulings that have been confirmed by the Constitutional Court that recognize rights to rivers. In the specific case of Atrado River and the Amazon River, sentences related to Bogota River as well here in the capital city of Colombia. Unfortunately, because of a lack of tradition and some attachment of compliance with those legal divisions, legal rulings, some of them, many of them tend to be just in paper, remain in paper, maybe because we're probably overburdening the judicial power and we don't pass those commitments to legislative and the executive powers. That's why we need to take that step. It has to be a legislative step in the creation of an environmental jurisdiction and an agrarian jurisdiction that is also the opening gate to institutions and formal situations to decide on these controversies when the state faces this. This is not a minor step. It's something that we have put off in Colombia, and we've been insisting on this as the General Prosecutor's Office for a long time. We need to give new tools to judges. We need to learn. That's the importance of the judges and ex-magistrates of so many countries that will be participating here in this specific case of the United States, a state such as Vermont with this long tradition of protecting the environment in the case of northern countries, Sweden, Chile, Guatemala, Brazil, so on. So many countries with very different realities that have set this single objective and single purpose is the creation of this environmental jurisdiction in our country. Because at the end, that's what it's about, to strengthen institutions. That's what we lack. We have lacked institutional capacities for many bodies, instances to aim at the same objectives, that comprehensive, holistic protection of the environment will have that chance to resolve those environmental conflicts. In the case of Colombia, according to the Environmental Justice Atlas, it's hundreds of conflicts that are taking place. I'd like to touch specifically on all the challenges, specific challenges that are placed by illegal mining, deforestation, logging that has turned into some sort of criminal cartel that we need to fight with tools, with criminal tools, the impact of coral reefs in Cartagena. We know it's one of the jewels Colombia has and the world has. That's why I believe that these conflicts are an additional reason to take that step forward. Plus, it's the starting point is the down payment to tackle all the conflicts we'll face in the future once we can sort out and hopefully soon be some sort of handbrake, emergency brake in the development of the world because of the virus, which hopefully there'll be a moment to reflect on the future challenges. And they make us think about so many new things, so many different scenarios. The role of victims, for example, of environmental damage, a discipline that is just beginning to take place in Colombia. For example, the way the prosecutor's office and the public ministry has started the popular action and popular some sort of class actions of in the Anglo-Saxon law that has helped us win these first battles. But it's not been enough. Yeah. We all know this in Colombia is one of the most diverse countries in the planet. And that's why we need to have greater responsibility when we face all these challenges and uh, strengthening our institutions when we find these tensions between the care for nature and economic development. I was saying I'd like to close with this that we have at this office, the General Prosecutor's Office, conducted many actions in that field in the years that I've been the General Prosecutor, not just because of the important role that we've given to the rights of nature, and from the very beginning, we have established the need of a jurisdiction to solve environmental issues, and I hope that step will be taken soon in Colombia, and I believe all our uh, speakers today who have joined this important event must become defenders of that cause. We, speaking of popular actions, started a popular action for the conservation of the Niki River in the San Andres Archipelago, one of the most important ecosystems in the world. We also started popular action to decontaminate the Cartagena Bay and Santa Marta Bay. It was a systematic disregard of the state and the private parties. The specific case of a town in Quindío, the Coffee region, we also started popular action for prevention uh, of disasters that were technically foreseeable. And we've been playing maybe the role. We've been very active there to negotiate the time the World Pact for the Environment. It was a meeting a couple of years ago in Bogota, and that was a landmark. What matters is that we continue to work on the need to create a tribunal, able to uh, enforce the law and allocate responsibility to the other parties. That has to be the arriving point of for the creation of jurisdiction, environmental independent jurisdictions that will be possible before the creation of the jurisdiction globally. That's why I request the President of the Republic we have to highlight that the adhesion to the Statute Agreement to facilitate justice and environmental democracy. I'd say 80% of our actions from the delegate for the environment, all our actions have always pointed on widening, expanding the possibilities of environmental justice as a mechanism not only for conflict resolution, but also as a key mechanism to defend the rights of Colombians. Robust environmental justice, a strong one, institutionalized, legitimized before Colombian society will be a key element to be able to continue to progress. That's why I'd like to conclude by thanking all of you for what these you represent, this compared law, the judicial, compared judicial experiences, the need to conceive environmental justice administration as another public service that is key to grant rights and to resolve so many conflicts of interest. This reflection that will do together is key. It's key in Colombia because of what it represents. The new debates that need to come to the Colombian public agenda are part of the global agenda as well. The application of new principles, the need to examine, for example, as it's being done in by the JEP, all the implications of the armed conflict and especially the pests of drug dealing and deforestation and how they have grown in Colombia. I cannot leave out how they're discussing the Congress of Colombia modification amendment to one of the institutions that is more important in Colombia and diligent about protecting the environment and the sanction of the predators of the environment that there's called the CARs, Colombian Autonomous Corporations. I like to invite all our countrymen and even international observers to keep an eye on this, on what is being discussed right now in the Congress of Colombia, because there again, there's been complete absence of the state. CARs in Colombia, as the environmental authorities in the regions, they are in debt to Colombian society. They have not performed their role. That's why this leads to the creation of that environmental and environmental jurisdiction when the levels of deforestation and environmental devastation, it's a paradox, have become stronger, bigger, and more have become more intense in Colombia. 100 days of the pandemic, we lack, as many have claimed, a record of devastated areas that we need to start tabulating to sort of specific zones and to open the. I discussed this with another delegate of the prosecutor's office to make a call to all Colombian organisms so that we can commonly look for a healthy environment, which is key for our food security in the future, not only for Colombia, but all developing countries after the social and economic crisis that will we will face after this pandemic. So thank you very much, every one of you. Rely on the support from our office, the Young Prosecutor's Office, the Institute of Studies of Public Ministry, that is part of this institution. We want this to be the starting point in the beginning of a big global reflection that we can all be key players, the state, the private parties, those of us who advocacy for the environment, and to enforce these initiatives, and they will not just be left in the quarantine as it's happened to many good social needs, but we can specify them thanks to the lights shed from some international experiences that are completely relevant to Colombia. So a big hug from our side and the greatest success in these sessions. Thank you very much, Mr. Carrillo, for your opening remarks and for introducing today's event. Before I pass on the floor to Carl, I'd like to invite everyone to select the interpretation icon and choose the language of your preference. Please select Spanish so you can listen to the interpretation from English into Spanish. Be reminded the sessions are being recorded and we'll be sharing them with you. We have over 600 people now on live YouTube. Carl, the floor is yours. Thank you.
Thank you very much, and good day, everyone. Many thanks to Dr. Carrillo for his comments and opening the series of webinars in such a motivating way. My name is Carl Brook. I'm Director of International Programs at the Environmental Law Institute based in Washington, D.C. Since 1969, ELI has played a pivotal role in shaping the fields of environmental law, policy, and management, both in the United States and internationally. We're an internationally recognized, nonpartisan center for research, education, and technical assistance. We help countries to strengthen environmental protection by improving law and governance in 4 key ways. First, working with local partners, we support the development of laws, policies, and institutions. We educate professionals and the public. We provide rigorous, objective data and analysis. And we convene diverse groups to solve problems. In partnership with the Global Green Growth Institute and the Consejo Superior de Judicatura, and with support from the Swedish Postcode Foundation, the Environmental Law Institute is undertaking a 3-year project to support the transformation of illegal logging in Colombia by building the capacity of the Colombian judiciary to hear and adjudicate cases on illegal logging and deforestation. Through 2022, the project will build awareness and technical capacity among the judges and magistrates in the 4 departments of Colombia most affected by illegal logging. The project will also train appellate magistrates in Bogota who would hear appeals from these departments. We're also undertaking complementary activities to support the Colombian judiciary in addressing illegal logging and deforestation. For example, we were asked if we might be able to inform ongoing discussions regarding the possibility of establishing and operating an environmental court or environmental chamber in Colombia. In fact, 2 of our core faculty for the judicial capacity building are retired judges from environmental courts, Judge Meredith Wright and Judge Anders Bengtsson. To respond to this request, we've worked with the staff at the Procuraduría General de la Nación to develop a series of 4 webinars to share experiences from other jurisdictions in establishing and operating environmental courts and chambers. Thank you all so much for taking the time to engage in this critically important dialogue.
Thank you very much, Carl. Interpretation is on the bottom of your screen, of your Zoom screen. It is an interpretation icon and you can listen to Spanish. This is today's next in the agenda. We'll listen to Meredith Wright on the audience concept and characteristics of the environmental jurisdictions. Then Judge Anders Bengtsson will bring a different jurisdiction model. And then conclude with factors to consider establish an environmental court. Before we start today's agenda, I'd like to tell you again about some ground rules to keep in mind. We ask you to write your questions only through the Zoom chat. We are in constant communication with the speakers so that they can respond to your questions. Together with the support from the Institute of Study of the Public Ministry, we will grant a certificate of attendance to those who have joined the 4 sessions. There in the chat, you'll find a virtual form so that please you can record your attendance to the 4 sessions. The attendance form will be shared several times in the chat. I'd like to introduce today's speakers. First of all, we have Meredith Wright from the United States, former judge, currently working for ELI as a distinguished expert and as a consultant on roles such as the application and enforcement of environmental legislation, specialized tribunals, and the rule of law, environmental rule of law. She was a judge in Vermont's environmental Court since it was created in 1990 until 2011. As an attorney, she's worked in the investigation, regulation of the environment, of environmental regulation, of local cases. Then we'll have Anders Bengtsson from Sweden, former judge from Land and Environmental Court in Växjö, Sweden. He has wide experience in practical application of environmental and environmental law in Sweden. He was part of the Land Court from 2001 to 2008. For several years, he's taken part in the organization of training sessions and training sessions on environmental law for the staff of the Environmental Court in his country. So that's it. Thank you very much. We welcome you to look at the chat for the questions and the attendance form. Marys?
Hello, will we have the,
Buenos días.
I'm sorry, will we have the presentation?
Estamos esperando un momentico la presentación, por favor.
Well, while it is being put on the screen, let me say good morning and thank you for the opportunity to share our experiences with environmental courts around the world. I'm honored to be able to do this, and Judge Bengtsson and I are here to be resource people for you. And we have, because of that, we have left a lot of time for questions. Has its fiscal system and its own country. Some of the countries like the US, Brazil, or Australia are federal countries. And in these countries, we may be talking about the different courts established in some of their separate states. Next page, yeah. I first want to raise some brief introductions about what we will be talking about in all 4 of these sessions. And today, Judge Bengtsson will go into much more depth on each of the ways, for instance, here of organizing environmental judicial work. Basically, within the court systems, environmental courts can be set up as separate courts in the judicial branch, or there are many courts which have set up independent chambers, or what are sometimes called green benches, where the work is done within the existing courts by judges who are separately assigned, specially assigned to this kind of work. And in some of these courts, the judges continue to do the other work of the court as well as the specially assigned environmental court cases. Also, in many places, the court-like functions are undertaken by an executive branch agency rather than a judicial branch court. And the literature in English sometimes uses the term tribunal for this type. And next session, I will discuss a little bit about the US Environmental Appeals Board, which is this kind of a system. Next. I also want to just mention, so that you will have in mind, the different ways that some terminology is used in different countries. I know in Colombia, magistrates are among the highest level of judge. In some countries, magistrates are, is the term used for the limited jurisdiction, lower level of judges, and the trial courts, the trial judges are called judge, and the Supreme Court uses the term justice. So when you hear those terminologies, just be aware that it's not always the same in each country. Similarly, as I've just explained, the judicial branch court may be organized as a separate court or as a bench or chambers. Within the executive branch, these are sometimes called tribunals or boards. This becomes a little bit confusing when translating into Spanish from English because of the use in Spanish of the word tribunal to mean court in general. Another area where terminology is somewhat different is in the words of the judicial decisions or opinions or sentences. And we will use all three of these terms in the discussion, especially in the fourth session in this series. And finally, bear in mind the differences between the common law and the civil law legal systems. But we wanted to point out that within the environmental field, this is mostly statutory law and judicial application of statutes. So the differences that some people perceive in these two legal systems are very much less within the field of environmental law. Environmental courts have been adopted throughout the world, and a recent report by the United Nations on environmental rule of law shows in its chapter 5 a map of the development of environmental courts throughout the last 20 or 30 years. They have been adopted in many countries for largely the same reasons. Many of the countries have very strong environmental laws and noble intentions with the environmental law, but there is inadequate and inconsistent enforcement of these laws, either between one area of the country and another, or even within one area of the country. There is also often delay in the courts system dealing with urgent environmental cases because when judges have to handle all the different cases that a jurisdiction needs to address, the environmental cases, which tend to be much more complex, sometimes are put aside so that the judges can work on the other issues within their jurisdiction. And finally, lawyers and parties in the environmental field have become frustrated with addressing their concerns to generalist judges who have not been educated about the scope and importance of environmental problems, especially judges who have not had any exposure to environmental law in their legal or judicial education. So the other thing to look out for in deciding to establish an environmental court or in examining environmental courts around the world is that there are essentially 4 types of cases which may be divided among different courts or may be combined in some of the same courts depending upon the legal system. We have, of course, criminal law, criminal courts, in which the cases are brought by the state against defendants and are primarily to punish bad behavior, but may also be able to provide restitution to victims. We have the civil law, which involves, in many countries, only cases brought against private parties or corporations. But in some countries, like the United States, civil cases can also be brought for enforcement of environmental law and can be initiated by citizens to prompt the action of the government to take enforcement action or to take it on their own. In these kinds of cases, and we will spend more time on this issue of civil penalties in a later session, but I wanted to mention that civil penalties are, unlike criminal fines, may be set at a level that removes the economic benefit that has been obtained by the defendant from the illegal activity, and especially in areas such as wildlife crime and deforestation, the availability of an economically based penalty can be a very important tool. The third type of case is the administrative type of case. Many civil law countries have separate administrative courts, as Colombia does and Sweden, in which cases may be brought challenging governmental action.
Pascual, sorry, if you can speak a little louder into the Spanish translation, and please speak a little away from the mic, because sometimes we can't hear you on the Spanish channel.
Thank you for that intervention. I will just say that, go back a little bit to administrative courts, which administrative cases which challenge governmental action. And in countries such as Australia and the US, the civil and administrative functions of courts are usually housed within the same court. And finally, there are constitutional claims and issues which may be brought under the Constitution, and different countries such as Colombia make it possible to bring these kinds of claims in any of the courts. So, as I have just said, some of these courts may be combined or separate, and as we talk about different examples, and as Judge Bengtson goes into more detail on these different examples, be aware of these combinations in the courts, or whether in certain places all jurisdictions may be handled by a single generalist judge. And finally, I wanted to point out the different types of cases that may come before environmental courts. This is the next slide. Some courts cover only some of these cases, with types of cases, with others going to the general jurisdiction courts. The next slide, please. But these may involve pollution control, regulation, and enforcement, which is often the first kind of case for which an environmental court is adopted. Harm to natural resources, the review of permits for different kinds of development or for land use, including agriculture and silviculture, and then harm to individuals and communities from pollution or from activities that exceed the scope of these permits, as well as cases brought under the Constitution. So with that introduction, that concludes part one of my remarks, and we will continue with Judge Bengtson, and then I will come back.
Buenos dias. Good morning. As I speak to you from Sweden, I maybe actually should say buenas tardes. But anyhow, I will tell you a little about the certain models of environmental courts and other solutions. And it's an honor for me to give my presentation to you. I have been working in an environmental court for several years, and actually I still work, but only one day a week at the court now. So I will speak to you from my experience as a judge from the environmental court, but also from contacts with judges from other countries and that works in other legal systems. As we already have mentioned, the role of the judiciary and the courts has been recognized to play an important role when it comes to environmental matters. And on this slide, you see some example of what has been written on this subject. For example, we have Professor Pring's two reports, Greening Justice and Environmental Courts and Tribunals, and also a book on courts and the environment from a symposium in Oslo some years ago. In my speech, I will try to give you a short overview of the major models and institutions and present some ideas what to consider when creating a specialized system for handling environmental matters. And so my speech and Judge Wright's will complete each other. And in the coming sessions, we will elaborate more on certain issues. This slide, I only want to point out some features that have an influence on any choice, whether and if so, how to establish an environmental court or a specialized solution to handle this kind of cases. For example, division of powers are quite different in the different countries. So my court, we deal with many cases, which I come back to next session, that would be out of the question and unconstitutional for a judge in Belgium, for example, to deal with. So it's one of the important issues that you must regard when try to solve this question, whether or not, and if so, how to create some specialized form of handling environmental cases. We have the different role of the judge, for example, that is very different in the different countries, especially when it comes to administrative cases. In penal cases, criminal cases, it's more or less the same principles that govern those processes. Next slide. So here is an overview of the main models that we will talk about. Specialized environmental courts and within or independent systems, what we call green benches, I will come back to that and give a little more presentation on that. And then we also have what Meredith already has described as tribunals, and in this connection they are within the executive branch and or administration, not regarded as courts. Some of them are very court-like. And then we also have other solutions, as for example having ombudsmen that are given special functions when it comes to environment. Our ombudsman in my country has not such powers, but in other countries they have, and also the prosecutor's role may differ. And in Sweden we have specialized environmental prosecutors. And next slide. So the most sophisticated model, if you say so, is what we call specialized environmental courts. And the most sophisticated and sometimes called the Rolls-Royce model is what they have in Australia and New South Wales, which Judge Wright will present next session, I think. These models, they are independent courts within the court system and have their own budget. And the one in New South Wales in Australia, it deals with both criminal and civil and administrative cases. And they have both law judges and science technical commissioners. The decisions are reviewed by civil and criminal appeals courts and the state's Supreme Court. Otherwise, the most common combination is to have the civil cases and administrative cases dealt with the environmental courts. And one other example of this independent courts is the one in New Zealand, Environment Court. And also the Brazilian Court of Environment and Agrarian Issues can we take to this category. The next category is where the Environmental Court is independent when it comes to their decisions, but otherwise they are part of the general court system as my court in Sweden. We have no own budget, for example, and we have the same administration at the court as the general court. So my court is, you can say, a mix of authority where we deal with permits in the first instance, and civil courts, civil litigation cases, and administrative courts. We are, as I mentioned, a section of the general court, but we have a different geographical jurisdiction. We have the whole south of Sweden we cover, and also we are exclusive forum for certain kind of cases.
Sorry, Anders. Pasquale, can you please speak louder and far away from the mic? We're getting feedback from the participants.
Okay.
That the Spanish is not coming out well and they can't hear you well.
Okay, sorry.
Maybe we can suggest that they use the option to switch off the original audio, because I have to increase my volume to be able to listen to Judge Blankston.
Yeah.
But I'll try. Thank you for your input.
Now, do you hear me better, I hope? I shall also mention that we have technical judges at our court, and we have a specialized appeals court with technical judges, and then the Supreme Court that has no technical judges. There are similar solutions in Australia, Queensland, and the Vermont, where Judge Wright comes from, is also to deal with this category of courts. Next slide, please. Now we will talk about green benches, and this solution is rather common in, not at least in Asia, and we have similar solutions in many countries in Europe, where you designate or assign courts or certain judges to deal with the environmental cases at the court or in a region, for example. In Philippines, they have designated special courts, and that is done by the Supreme Court. And otherwise, in many of European countries, especially then those who have administrative courts, use this system to allocate environmental cases to one or certain judges at the court in order to get better knowledge of these often rather complicated cases at the court. And then you also have another solution is to train all judges in environmental law, as has been done in Indonesia, for example. But that depends also on how many cases you have, and so there are many factors that you must take into consideration. Next slide, please. You have also tribunals, what we now call these institutions that are within the administrative body and not here what we call courts, even if many of them are court-like. We have an example from Denmark, for example, the chairs of these tribunals that deals with environmental hazardous operations, for example. They are often judges from high courts. And but the other solutions, they can be a mix of judges, lawyers, and scientific and technical experts, and also NGOs and lay persons. Some of these tribunals only have lay persons and no judges or lawyers. They can be dependent on how involved they are in the administration and the authorities which decisions they will scrutinize. They can be departed into independent, quasi-independent, or what Professor Pring has called captive environmental tribunals, where the tribunal is within the same authority that is monitoring. And then we have alternative dispute resolution, and this is a practice that is used in many countries. Instead of having the citizens or persons go to court. Sometimes you have a separate system for these dispute resolutions, especially when it comes to disputes between neighbors. Sometimes they are close connected to the court that you have to go through this mechanism before you open a case at the court. Many of these commissions, or what you can call them, are governed by a judge at the court, so they can be both external or internal mechanism, and it's a rather handy kind of solution for cases where the parties don't have to open, especially if the alternative is to open a civil case. Then this is much more, can be much more effective, and you can make solutions that the parties both accept. In the long run, you can gain from this kind of system. And also you have mediation in the court. We have, it's obligatory in civil cases that you must mediate before you try to get the parties to reach an agreement before you go to a session with the parties and have the main hearing. Yeah, we can switch to next slide. So we have criminal cases, and I don't know really the conditions in Colombia, but in my country we have rather few cases, criminal cases a year, and at least when you see to how many cases each and every judge get. So maybe you have one environmental case every second year, and then it's hard to keep up your competence then. And also the legislation is rather tricky, and there can be gaps, and the provision in the penal law is you must cannot read by itself. You must set it in the context of the major environmental laws, say the waste law, that is rather complicated. If you have a violation of illegal dumping or something like that, then you must have a more general view of the legislation, and that puts a rather heavy burden on the court and the judges. And then you often have this technical and scientific evidence that is rather tricky to go through. It can be complicated, and it can be very extensive as well. And for a judge, especially if you don't have dealt with environmental cases for a while, then it can be rather tricky, to be frank. We have discussed this in our country on several occasions, whether or not to have these cases allocated to the environmental court, but so far nothing has happened, and there is arguments against, for example, that we should develop a special practice that would not be in conformity with the general practice on imprisonment, for example. And also it could be regarded as we are defending our own previous decision when we have dealt with them as administrative court. And then we also have this problem when the environmental crime can be combined with other crimes as well. And so there are pros and cons with this. And but anyhow, there is a proposal that we should at least gather the environmental crimes to those courts that have environmental courts, but then to the general court. That would increase the caseload. Next slide, please. Civil cases, well, we have, that's not so much to say here. I will mention that for example, our system is built that the environmental court is exclusive forum, that only we are allowed to deal with the environmental matters. And then, for example, if you have a case where there are cross actions or set off defense related to general tort law, then we can't deal with that, and the general court can't take the whole dispute either. So that's deficiency in our system, I will mention. Otherwise, in civil cases, there can be special rules that ease the burden of the plaintiff in some cases regarding environmental damage, for example. But also here you have the technical and scientific evidence that this can be very tricky and extensive for the court to handle. Next, please. Administrative cases. Here it's much dependent on which system you are in and which legal traditions you have in your country. How deep you must go into the matter. For example, in our country, in most cases, we have a merits review, while in other countries in Europe, the most common is to have a judicial review. We have a reformatory procedure in our country, meaning contested a decision, we can put another new one in its place, for example. So in a way, we act as the first deciding authority when we have a cassatory procedure, meaning that they can only revoke the decision or have the say yes or no. So that's if you have this judicial review and a cassatory procedure, then you don't have to dive that deep into the evidence of that can be very tricky. While in my country we are obliged to do it, and that means that we in our country are very helped with the access to the technical judges. Next slide, please. So we have talked much about scientific and technical evidence, and we will come back to that in a later session as well. This is one of the main problems for the court and how to deal with it, because it can be very complex, and if you are not educated in the area at hand, then it's much to put your eyes on and try to analyze and reach a decision. It's not easy, I would say. And then you have different kinds of ways to solve this problem. You can have internal experts or technical judges that have been mentioned. We can have external sources where the experts are appointed by the court or by a party. They're different in different kinds of cases, of course. We can go to governmental authorities, that is practiced used in many countries, for have an opinion from the authorities. You can go to academia, and sometimes the NGOs have their own experts. Next slide. So to end this short session, I will give you a picture of a hearing at my court, and I heard Judge Wright said it could as well be a picture from her court. A hearing at the Växjö Land and Environment Court. Thank you very much. Gracias.
I think while the next PowerPoint is being set up, I believe that if questions occur to you as we are speaking, you should feel free to put them in the chat as a question for the later session. You don't have to wait until that session starts.
Thank you, Meredith and Anders. We're just collecting the questions that we're receiving through Zoom, through YouTube, to present them to the speakers when we finish the presentations. Okay, so feel free, please, to write the questions as they arise, and we are collecting them so that we try to answer them at the end today in our QA session.
Okay, so I will go through fairly quickly a set of factors that that anyone looking at establishing an environmental court or changing the way environmental cases are handled within their systems should consider all of these factors. I'm not going to give you any solution to what the answers should be about any of these factors, but these are the things that we will try to address when we're describing the different courts in sessions 2 and 3, and that we will discuss more fully and discuss with you in session 4. First slide. So the first things to consider are the structure and the jurisdiction of the court. The first question is, what type of forum is it going to be? Is this going to be within the judicial system, either as a separate, completely separate court, or as a separate court within the general system, as the Vermont and the Swedish courts are, or a green bench or specialized chamber or assigned judges as the Hawaii court is. The next issue is whether such a court is going to be established only in the first instance courts with an appeal in the general way that any appeal goes in the general court system. In Sweden, they have, I think it's a series of 5 first instance specialized courts going to 1 specialized appellate court. In Vermont, which is a much smaller jurisdiction. We have the single first instance court, and there's no intermediate appellate court. So all trial cases go to the Supreme Court of the state. Within each type of court, there could be an environmental section or chambers, or civil and criminal and administrative and constitutional claims might be able to be brought in multiple courts. That depends, I think, a larger amount on the judicial system of the place than it does on making a particular choice. But let me mention that the issue that was brought up by Judge Benson about the problem of having environmental cases in the environmental court and a related, let's say a boundary dispute or a related land dispute in the civil court. One of the ways that we have handled that is to, for that particular case, to associate the cases and assign a single judge to the both cases, so that even though the cases remain in the separate jurisdictions, any evidence can be taken and hearings can be conducted more efficiently just one time for both cases. Next slide. Continuing with the structure and jurisdiction of the court, it is necessary to determine what geographic area the court will cover. It has not been an issue in the two United States that have these kinds of courts, because it is a court that covers the entire state. Within places like Sweden that have a unitary country, but have had to divide the country up regionally in order to provide an appropriate amount of coverage, you have to determine what makes the geographic area a sensible one for the division. And some people are talking recently about that the political divisions don't always cover the biological or watershed or other areas that make more sense from an ecological point of view. So I think it would be conceivable to have a geographic area that consisted of, for example, a watershed of a major river system, and have the courts consider cases within that area. But I don't know of any country that has set things up that way, at least as of yet. The final issue within the sort of structure and jurisdiction is the substantive jurisdiction of the court, that is, determining what substantive areas of the law will be covered by this court. Those areas being the things that I essentially listed in the final slide of the first part. One of the considerations about this is whether picking a jurisdiction of all those kinds of cases will make the workload too great for the number of judges assigned to the environmental court. When the Vermont Environmental Court was created in 1990, and I had the opportunity of getting it started, it was one judge for the whole state, which made the jurisdiction and workload issues interesting. I will tell you more about that next week. Next slide. Then beyond jurisdiction, there are issues about the facilitating or not the participation of people in the cases that will be able to be brought to that court. This is less of an issue in purely criminal jurisdiction, where it is always the state bringing the case and always a defendant on the other side. But even in criminal cases, there is the issue of whether people who are affected by the problem that is at the heart of the criminal case can come in and participate in the case, even as witnesses. So the victims, so to speak, of the criminal case, there must be ways of determining who can come in and give evidence about what has happened in that case. And clearly in civil and administrative cases, there is the issue, which is usually set up in a statute, of who can bring an action. Can it be brought by individuals? Can it be brought by a community group, an indigenous group, a NGO on behalf of various groups? And may cases be brought on, or even in the name of natural systems, or on behalf of nature as a whole? And there are some countries that have the right to go to court on behalf of nature written in their constitution. I don't know of very many cases where that has actually yet been used, but that is certainly something to watch. Then there's the question of making it affordable for people to go to court, or how to reduce those costs so that people can make use of the access to justice. Some of these expenses are just the charges for filing a case, if there is one. But some of the other expenses are a feature of the way that the particular judicial system allocates costs. So in the systems in which the losing party has to pay the winning party's costs, it is a much riskier job to decide to bring a case, and that kind of a rule can discourage people from bringing appropriate cases. So there have been the UK where those rules are relaxed or changed for environmental cases or cases representing the public interest. There is also the question of geographic access. If you can't get to court to file your case, or to attend at a hearing, then no amount of access on paper is useful. And that is particularly an issue in certain ecosystems, such as the Amazon. So you need to consider, how will parties get to the court, or will the court travel to the parties, which has actually been done in a number of places with traveling courtrooms by boat, or by a bus fitted out as a courtroom. And also where there are courthouses or meeting rooms in various places around the jurisdiction, judges will travel to hold the hearing in a place close to where the problem arises, or where the parties live, rather than making them all travel to a central courthouse. And we will address that a little bit more in some of the later sessions. Next slide. And then it's necessary to consider whether the court has the procedures that are helpful in making the court's work go efficiently and effectively. Judge Bengtson already addressed the availability of alternative dispute resolution. This is not necessarily something that actually occurs at the court, although some courts do provide mediation services with personnel who are located at the court. But other systems require mediation to occur before the case can go forward in the court to see whether there is a way of resolving it before making use of the court resources. The next issue is whether the court has the appropriate procedures to move the cases efficiently and effectively without unnecessary cost or delay. This does not necessarily mean moving them very fast, because in some instances, moving them very fast is not the best way of handling them. For example, if you have a case involving several different permits, several different licenses required for a particular project, it is sometimes more efficient to make sure that all of the necessary cases or judicial review cases have come into the court so that the entire project can be considered as a whole. That may mean holding up on one case while waiting for the other case to come in. In other instances, certain legal issues may need to be resolved in the case in advance of going forward with taking evidence. So the important thing here is for the court to have management procedures, possibly holding a case management conference with the parties to tailor the procedural needs of the case to the particular case. And third, does the court have adequate enforcement tools and remedies to apply so that when it makes a decision, the decision can actually have a real world effect and not just be a decision on paper? Next slide. Then there is the question of how does the court obtain the necessary scientific and technical expertise. This was raised by Judge Bengtson. And finally, the final slide, the next slide, how to best to ensure the competency and integrity of the judges serving in the court, considering the qualifications to be a judge in this specialized area. This is the next slide. And the needs of continuing judicial education, such as the project that the ELI is undertaking in Colombia. Thank you. Gracias. This concludes this presentation, and it is time to open up the discussion for questions.
Thank you very much to the two judges for the information they've shared. Before we go to a question, I'd like to let you know that this training was designed for the judicial prosecutors and other judges that we've been working with during work tables regarding environmental jurisdiction. Given the interest that we have 600 people connected in YouTube, asking a lot of questions. They're interested in these training, which makes us very happy. We have for those people who are registering the 4 YouTube sessions that will be given the next 3 Thursdays. Another 3 After this, also the recordings of the meetings will be available in a platform that will be informing soon once we have the recordings, the talks, the presentations. By the presentations, once the speakers authorize that they be shared. We have received many questions. We have about half an hour to ask some questions. We're going to try to approach them. I will ask, and I'll just read the questions, and then they decide who would like to answer. The first question, I'm just altering between questions from the Zoom chat and the YouTube chat. We're trying to respond to platforms. The first question, should we include in the cases that are heard by these court issues related to prior consultations that have to do with ethnical communities? Again, I think the question is whether they should include in these courts the cases, the prior and informed consultation. Whoever would like to answer, Meredith or Anders?
I'm not familiar with the consultation mechanism. Certainly it is important on two levels. First of all, for all communities within the country to have access to such courts. And then it is also important for the decision or the result of the case to take account of the needs of the people who will be affected by the decision, and in particular to be respectful of the rights and the needs of particular communities. But Colombian law, so that's about all I'm able to say about it.
No,
Judge Bengtsson, are there separate resolutions for the Sami people in the north of Sweden?
I'm not so familiar with that law, but they actually have. Regarding this population that is regarded then as indigenous people, and so we have had many conflicts with them, where the conflict with the exploitation of land areas, for example, building windmills, and then the weighing of interests between the interest of green energy and the Sami people's rights to have their land to transport the reindeers for grazing. And so there have been many consultations, of course, but that's in a stage before the case reaches the court. We have had disputes in the northern environmental courts, but also in civil courts. And one case regarding hunting and fishing was solved by the Supreme Court just this spring. And so there are many conflicts, but I'm not that familiar with the mechanisms.
Thank you very much. We have another question about conciliation. The question is, what types of cases does conciliation, prior conciliation or mediation apply? And is it mandatory before you access the environmental courts?
If I start this time, regarding civil cases, we have no such obligation, but in some countries in Europe there are, that you should go through a procedure before you enter the court. But in my country, when you enter the court, then we start to try to mediate. We can do it with the court judges, or we can appoint an external mediator as well. In administrative cases, I think it's more common to have this kind of commissions and peace judges and so on to try to solve disputes, minor disputes, and mainly disputes between neighbors. And I will, some of these are little like the tribunal. So the division between these commissions and the tribunal, it's not really easy to draw an exact line, because they sometimes they have the same obligations and possibilities to solve the case, and they can be constituted in the same manner with a similar kind of people, judges or laymen and specialized technicians, for example. So there are examples where they, in Europe, where you are obliged to go through such a procedure before you enter the court. But that's probably more common when it comes to administrative cases than civil cases.
I should point out that when a court system provides judges are not the same judges who sit on the case if the case goes beyond mediation to a court case. Except in China, they have chosen to have the same judge mediate, and it's been an interesting discussion, because in the United States, it's not allowed, the judges who hears a case is not allowed to hear anything about settlement discussions. In the Vermont court, which is not criminal, but essentially what you would classify as civil and administrative, we do try to require mediation in almost, well, both of the judges think we require it in most of the cases. It turns out it's done in about 2/3 of the cases. So what you have to be careful about with mediation is that there's an advantage of mediation, which is that it can sometimes solve a problem that is larger in scope than the problem that can come before the court's jurisdiction. But what you have to be very careful about is that the relative power of the parties in the case doesn't affect the mediation, and that turns out to be something that trained and skilled mediators are very good at. But that's an argument for not using just anyone to mediate a case.
Can I add that in my court, also in civil cases, where the judge that have the case allocated to him or her are allowed to make the mediation, but then depending on how hard you go through this procedure, you may be tainted, and then you leave it to another judge when it comes, if you don't succeed. But we often, or most often, we start ourselves. But then, depending on how the mediation goes, then we may leave it to another judge. And then in administrative cases, especially, one other problem is that you can't mediate in a way that is binding for a third party, or or for public interests. That's a little tricky when it comes to interest for the nature, for example, how you can make a mediation for a permit or so on. So there are restrictions in administrative cases, especially.
Thank you. I'd like to pass on the Carl to bring clarity on one of the questions that was asked.
I just wanted to follow up on the question about free prior informed consent, because I think that this is an important issue in many countries, although it's framed differently. Meredith and Anders, I think a lot of the context for this is domestic legislation implementing ILO Convention 169, which requires governments to secure free prior informed consent from indigenous communities, indigenous peoples, when a project might affect their land, their forests, or other terrestrial resources. And so there's a procedural aspect to this, like EIA. And I didn't know if those sorts, if an agency does not secure the free prior informed consent, or if the developer does not secure the free prior informed consent, is that the sort of thing that might be challengeable in a domestic environmental court?
I should think it would be, because it is a procedural defect, just as failing to provide what's necessary as a prerequisite to a permit. So regardless of whether the court could reform a permit decision or had to only, or if it was only cassatory in nature, that would still be an issue of whether the permit was properly obtained. But, and then there is the systems in the United States where the certain of the tribes have their own court system. So, but that goes way beyond this question.
I can add that Sweden is not actually a part of the this ILO convention. It has been discussed for many, many years, but still we are no party to that convention. But anyhow, in this judgment that I mentioned that came during this spring from the Supreme Court, the court actually, when it recognized the rights of the Sami people, they based arguments on these overriding principles, irrespective that we are not party to this ILO convention.
Thank you. Another frequent question that was asked had to do with the professional who would be supporting the judges. So our question is, what criteria should be placed to appoint those experts or those support individuals? What's the role of that expert, scientific or clinical expert? And if they are appointed based on a jurisdiction, are they appointed by the court, or they only intervene after being requested by the parties? These are the questions related to the role of technical experts that we wouldn't call them exactly an attorney or lawyer, but their role in this court, on this jurisdiction. What is their role? What is their participation if it's requested by one of the parties, or how is it handled with?
I think to answer this question, you have to distinguish between courts that have scientific and technical experts sitting as judges all the time or assigned to cases within their expertise, such as a mining expert or a forestry expert. And the New South Wales court has these sorts of people called commissioners. They do decide some cases within their expertise on their own, and others they sit with the with the law-trained judges. And Judge Bengtson will talk about how they handle the technical experts who sit on their courts. But that's a very different question from how do you get the appropriate scientific or technical evidence into court when you don't have these experts sitting as judges. So I'm going to turn this over and assume we're only talking right now about technical and science experts sitting as judges. And we will get to the question of technical and science experts being brought into court as for evidence, but that's a separate question.
I can add that in Sweden, when we talk about the law-trained judges, the law-trained judges are appointed as judges at the General District Court or the Appeals Court. And in principle, they then can work with any case. But to work in a Land and Environment Court, you also have to be appointed by the president of the court to work in this section. And we are appointed as judges by the government. And then in order, when you apply for to be a judge at the Land and Environment Court, of course, you take into consideration if there are several applicants, if anyone can show that they have been working with the environmental matters before at an authority or a governmental level or anywhere. So it will play a role when they are hired as judges and then appointed by the government. And also our technical judges are appointed by the government, but they are appointed for the whole country, even if they in practice only work with one of the 5 land environment courts. Their qualifications are a little tricky to evaluate, and we have then started to have some technical tests, how they analyze a problem in order to combine that with other qualifications, that they have an academic degree and then they should have worked with environmental matters. But then it's very important also that they can fit in with the special culture at the court and the role of a judge that is quite so what it is have been working with them before. So this is a rather delicate question, but it functions in practice. It functions very well, and we are very pleased with this system.
Thank you. Another question has to do with the sanction competencies. The team I'm part of, we've been discussing with foreign judges the specificity of our Colombian organization with the environmental authorities have certain competencies to sanction. The question is in the sense that if these courts or tribunals will remove the sanction competence from the CARs in Colombia, if that's likely, that has been documented, how they have done this because they have not complied with permits or damages, if that competence is passed on from the administrative authority, the CAR in Colombia, to a court or environmental court or tribunal.
I don't think I understand the question, but perhaps I just didn't hear it completely.
I have, I'm not sure, but at least it makes me think of one thing, and that is the role of the court in some of the European countries, and I don't know how it is in Colombia. The complaints to the court is from a private person, for example, or NGO, against the state or against the local authority. While in my country, the complaints mainly are from one private person against the opponent, private persons, and then the authority that has made the decision, they are regarded as party as well, but the main conflict is between the private parties, between the neighbor and the disturbance factory, for example. So I'm not sure if that was the question, but there is such a division in Europe between who is filing the complaints and against which.
Please listen this. I'm going to try to paraphrase the question. The question was, here in Colombia, the CAR. The question was that here in Colombia, the CARs, which stand for Autonomous Regional Corporations, have the capacity of sanction, to impose a sanction on a party, okay? So the question is, if in the case that non-environmental court is structured, would that remove or take that power, that authority that the CARs had? Do you know if this has happened before? Do you have any information about this? How could it be done?
I think I understand now. We don't have I haven't seen this exactly the same issue, but it seems to me that the CAR's authority would be treated as if it was the lowest level court decision. And then if anyone wanted, if this would be completely a question of how the law was established to regulate the relationship between the CAR's process and the court's process. But it is certainly not, it's not uncommon to have a regional body making a decision, and then anyone who wants to challenge that decision, bringing that case then to the court. And for an example, in Vermont, there are regional commissions that make the initial decision on development permits for large projects. And often the court will receive an appeal of that decision from the permit applicant who doesn't like some of the conditions imposed on the permit, from the neighbors this way down the road who think the conditions are not strict enough, and from the municipality who has another approach to the desired results. So you get cases with all of these parties coming into the court, but after the municipality or the regional board has ruled. So it certainly could be set up that way, but I think it would be a matter of the Colombian law.
Yeah, I also recognize this, that we have the local authorities and also regional authorities has the ability to impose environmental sanction fees on for minor offenses of the environmental law, and those decisions are regarded according to the European Convention on Human Rights as punishments as criminal law, and then but they can then and must be able to be appealed to an court, and those decisions are appealed to the Land and Environment Courts. And I think that they have similar systems in other countries as well.
Thank you very much. I'd just like to add that these international models that we'll be discussing in the coming section and in other countries that we could not approach are not straitjackets. These are not structures that we have to adapt to. We have to adapt our system. The Colombian legal system has some specificities that we do not share with other countries. So in the case when we decide to create a specialized jurisdiction for the environmental country, those are the discussions that need to be held, how to adjust our system, our CARs as the environmental authorities and get better results, which is environmental protection in the end. So my opinion is that not necessarily do we have to adapt foreign models, but to find the formula, the local formula. I have a question in English for the judges. If you can help me read it, it's in the chat in English. I'll translate it, and it has to do with another question. Basically, former judge from the Chilean Green Tribunal, Professor Intunza, told me that the work of the tribunal could be very frustrating because lawyers and scientists, the judges, could be lawyers or scientists as well. We're trapped in administrative law procedures rather than in environmental law. In that aspect, how is the experience of US and Sweden? I repeat the question. How is the experience of the United States and Sweden, where it indicates that, let me see, let me read again. A judge told me that the work of the tribunal could be very frustrating because lawyers and scientists were trapped in administrative law procedures rather than in environmental law. In that aspect, how is the experience of US and Sweden?
At the risk of appearing to just put off this question, and I do hope that you can attend next week's session, I think that this is something that we can address in more specificity and detail next week when we are talking specifically about the US and Swedish courts. For myself, I don't find this problem, but we treat the cases a little differently. And I think perhaps it's because both in Sweden and in Vermont, we do not have we have a reformatory procedure, so we can actually take substantive evidence and determine what is the best result under environmental law, rather than only sending it back to be done over by the administrative agency. But we will address this more next week.
Maybe I just can add that there can sometimes be a collision between, for example, environmental law and then principles of legal rights for the defendant, also in administrative cases. But of course, we have to apply the administrative law that's and overriding principles, and sometimes they can be conflicting, and that's can make it tricky for the court, of course, in individual cases. But it's also make the work stimulating as well.
Even when it doesn't look like the picture that Judge Bengtson provided.
I'm gonna ask two more questions so that we abide to time. A question that we've approached during our discussions, and is that here in Colombia, we suggest to use or include the environmental jurisdiction in the agriculture topics within the same specialty. So the discussion is if they're not compatible and they should be separated into different instances. In your country, based on your experiences, are there land use topics or rural topics in combination to environmental concerns, or do they go separate ways?
Yes, I think this is a very important question. In Vermont, the issues of agriculture and particularly preserving agricultural soil from development is a key issue in the law that the court operates under. So we are applying that along with the other environmental ideas in, and really most of the Vermont court's work is in the land use area. In New South Wales, in Australia, the title of the court is the New South Wales Land and Environment Court. And it also covers those issues, and particularly issues of forest preservation in their dry climate. But I'm not sure what all the agriculture issues are in Colombia that might be appropriate or not appropriate to be combined.
Some of the issues regarding agriculture we will deal with. We can have it in planning cases and building cases where such areas are regarded as of a national interest, agriculture areas. So you are not free to build houses on such land, and there have been many disputes on that issue. And then we also have in the spreading of pesticides, for example, that would be a matter for the court if there is a complaint regarding how a farmer spreads his pesticides, and also the permit to spread such components can be challenged at court. And even the shift of land use from farmland to forest land, for example, would be a matter that needs a special permit, and those decisions can be challenged at our court. And also we have this regarding forests. There are a specialized forest legislation that is not under our jurisdiction, but certain aspects of forestry will come under our jurisdiction if it's protected areas or protected species within the forest, for example.
Thank you very much. I'd like to end this session to cope with time. Pointing out several things. We have received very many questions at a very high level. This shows the importance, the relevance of this topic for our country and the level of discussion that's taking place. This is why we were not able to answer all the questions today. In the coming sessions, we will have QA sessions. At the last session, there'll be time for more general discussion. I personally commit myself to reviewing the questions and then request the speakers to include these aspects in their future presentations, things that the attendees have asked. So we will review that. The members of the team will review that to guide the future discussions and try to answer the questions that were not answered today. Remember, the attendance form is available. We will certify the attendance for those who sign up for all the 4 sessions, and we'll be sharing also material of these volunteers of the trainings. I'd like to thank by thanking the State Council. This is the High Court that is leading this topic in our country, and we hope that this will contribute to the discussions that are taking place at the different sectors: the environment, justice, agriculture. Well, thank you very much, everyone, for your attendance. We are very pleased with this warm welcome. How much interest it arose. We received many more people from many different territories. Thank you again for the interest. We'll keep in touch through email to inform about future sessions. Thank you very much again for your participation.